All right, still with us, criminal defense attorney and former prosecutor David Bruno and criminal defense attorney, former district attorney Matthew Mangino. David, I'll start with you. At least in my experience, this type of charge, you generally see some sort of bond set. There was not bond set here, and again, the criteria is basically a reasonable assurance that the person will return and whether they're an unreasonable danger to the community. The second one seems like it might be an issue, but there are conditions that you can mitigate that danger. Your thoughts? The judge decided not to give bond in this case, and I submit the high-profile nature and the really devastating testimony of the victim's family here played a role, had to have played a very big role.
Yeah, we also heard a sound bite from the victim's mother about some sort of history of failure to appear. And that is also a relevant factor in this analysis, too. A lot of these jurisdictions, and we're hearing about this in the media over and over again, have gotten away from monetary bail, and it's a risk factor. It's a set of factors that the court analyzes whether or not they're a danger to the community, they're a threat to destroy evidence, and whether or not there's a risk that the defendant doesn't reappear. So that may have been a factor in the analysis as well. But Michael, real quick, I'm a former homicide prosecutor. I prosecuted these cases. I'm on the defense side. I defend the cases now. These are the toughest cases on both sides because of the lack of purpose of the defendant, and you could see it pouring out. I don't know if those are tears that she's going to be in jail or because of the sorrow of hearing the family, but in any event, when a person gets behind the wheel intoxicated, it's reckless, it's not purposeful, and there is losses on both sides. My heart goes out to the victims specifically here after hearing what they had to say.
Yeah, we've heard jailhouse phone calls, and I think she's genuinely remorseful of the consequences of her actions as her life. She's still a young person, so she realizes the devastating consequences it has on just about everyone involved. Matthew Mangino, you know, she drove 2 times the speed limit. The blood alcohol was 3 times the legal limit. Those are serious numbers. But going to David's point, a lot of people say, you know what, this is really a mistake with some dire consequences. But at the same time, a lot of other people are wondering, why isn't this charged more like an intentional act? You drank those things intentionally. You intentionally got behind the wheel of a car, which under these circumstances is a dangerous weapon. So explain to people why that might not be the right move here.
Well, you know, this is extremely reckless. You're drinking so much that you're twice the legal limit. You're exceeding the speed limit by a significant amount. I mean, that is about as reckless as you can get. Now, you know, there's no intent here to go out and to get into an accident or to cause the death of someone else. And that's the issue here. This is an unintentional act, but it is so difficult to comprehend because of the randomness of it, especially when you look at it from the victim's perspective. You know, a lot of times, you know, people are in the wrong place and they're doing the wrong thing, and somehow they get caught up in a situation that caused their injury or cost them their life. This is completely random. She's coming from her wedding. She's in a golf cart. She's killed. It's gut-wrenching for her family, regardless of what the circumstances were that brought about her death.
Now, David, you've prosecuted and sort of defended these types of cases. We got reckless vehicular homicide, 3 counts of driving under the influence causing great bodily harm as well. There's no dispute. I think she admits what she did. Again, the level of recklessness might be a question. How do you think this one might play out? This one seems ripe to me for some sort of plea deal if both sides can get on the same page.
Yeah, it's going to be hard, though, because you hear from the victim's family right here in this hearing, and there are rights that victims' families have in consultation with the prosecutors, and prosecutors often lean on them as to what an appropriate plea offer is. Yes, based on what has been established here, if that BAC is an admissible piece of evidence, namely that they took it right and the analysis is right, and you have the black box, which typically has the speed. If you have the combination of both speed and intoxication, this really is something for the defense attorney to negotiate down, but it's going to be tough because of the family's input, and we heard it here today.
Yeah, and the high-profile nature of the case. Let's not forget those things do affect. Judges are elected, just like a lot of other officials. All right, folks, coming up next.